Hello, everyone, and welcome to Internet Law Review. So, for today's story, we are going to cover this brand new case from the United States Court of Appeals for the Sixth Circuit. This is the case of Cruz Gullas versus Minard, a police officer, and deals with whether or not it is legal to give police the finger. So, let's read a little bit more, shall we? Sutton, Circuit Judge, writing. Fits of rudeness or lack of gratitude may violate the Golden Rule, but that doesn't make them illegal, or for that matter punishable, or for that matter grounds for a seizure. Officer Matthew Minard pulled over Deborah Cruz Gullas for speeding. He wrote her a ticket for a lesser violation, a non moving violation. As she drove away, apparently ungrateful for the reduction, she made the all too familiar gesture at Minard with her hand and without four of her five fingers showing. That did not make Minard happy. He pulled over again and changed his ticket to a moving violation, a speeding offense, and what counts as more serious violation of Michigan law. Because Cruz Gullas did not break any law that would justify the second stop and was at most exercising her free speech rights, we affirm the district court's order denying Officer Minard's Civil Rule 12C motion for judgment on the pleadings. Minard, a police officer in the city of Taylor, Michigan, stopped Cruz Gullas in June 2017 for speeding, but he decided to show her leniency and wrote her a ticket for the non-moving violation. As she drove away, Cruz Gullas repaid Minard's kindness by raising her middle finger at him. Minard pulled Cruz Gullas over a second time less than 100 yards from where the initial stop occurred and amended the ticket to a speeding violation. Cruz Gullas sued Minard under Section 1983, alleging that he violated her constitutional rights by pulling her over a second time and changing the original ticket to a more serious violation. By Section 1983, the court means 42 USC 1983, but it is used so often that most courts just simply abbreviate it to Section 1983. Basically, this section of federal law says that it is illegal for any state official, police or otherwise, to violate any of your federal constitutional rights. And if they do, it gives you a cause of action against them. So this is pretty much the most common basis under federal law to sue a state official of any kind, police or otherwise, for a violation of constitutional rights. The court continues. She claims he unreasonably seized her in violation of the 4th and 14th Amendments, retaliated against her because of protected speech in violation of the 1st and 14th Amendments, and restricted her liberty in violation of the Due Process Clause of the 14th Amendment. Minard moved for judgment on the pleadings based on qualified immunity. The district court denied the motion, reasoning that Cruz Gullas could not be stopped a second time in absence of a new violation of law, that she had a free speech right to make the gesture, and the gesture did not violate any identifiable law. Minard filed an interlocutory appeal, arguing that he's entitled to qualified immunity because, even he assuming he violated Cruz Gullas' constitutional rights, those rights were not clearly established. So, an interlocutory appeal is the name for an appeal while the trial is still ongoing. As I covered in a previous case, normally you cannot appeal a decision from a lower court until the case is completely done. But under certain circumstances, you can appeal while the trial is still ongoing, and this is one such occasion where the court granted the request. So, interlocutory appeal means the underlying trial was still ongoing at the time. Qualified immunity is a doctrine that basically provides that any government official that is operating in their official capacity is entitled to a degree of immunity for official acts conducted while they're conducting their activity. And the rationale for this, especially for police, is fairly clear. The police have to make a lot of snap judgments all the time, and if they had to worry about their own liability in every situation, it might inhibit the ability of police to conduct their mission. Now, obviously, that comes with a lot of trade-offs, because if they violate people's rights, then there's no cause for relief. But at the moment, at least, society has made this tentative judgment that the police need the ability to act quickly in response to crisis scenarios rather than people being able to recover. So it's a qualified immunity. But the term qualified means that it's not an absolute immunity. For example, police officers are not covered if they're acting outside their job, and they're not covered if they're violating a decision that is clearly established. So that is the dispute that's ongoing at this point. In the court's words, qualified immunity protects police from personal liability unless they violate a person's clearly established constitutional or statutory rights. And then the court, writing for itself, says the rights asserted by Cruz Gullas meets the standard. This means that the lower court is going to have to say that the officer himself is personally liable for this stop. So this means he can come after the personal assets of this officer. So this officer who decided to pull over this person because he got the finger is going to be on the hook from his personal assets for making that decision. The court continues. Under the facts set forth in the complaint, Minard violated Cruz Gullis's right to be free from an unreasonable seizure by stopping her a second time. So the term seizure just implies to anything that's taken, normally held to property, but seizure of the person is an arrest or detention, and this certainly qualifies. All agree that Minard seized Cruz Gullis within the meaning of the Fourth Amendment when he pulled her over the second time. To justify that stop, Minard needed probable cause that Cruz Gullis had committed a civil traffic violation or reasonable suspicion that she had committed a crime. He could not rely on the driving infraction to satisfy that requirement. Any authority to seize her in connection with that infraction ended when the first stop concluded. So we see immediately that he had cause to stop her the first time. He made a decision to write her a ticket for a lower offense, and as soon as he was done with that, his authority stopped. So he could not seize because the need for the seizure had stopped. And flipping him off did not qualify as a new grounds for seizure, so he had no grounds to seize. Therefore, it's a Fourth Amendment violation. Pretty cool, huh? The court continues. This leaves Cruz Gullis's gesture as a potential ground for the second stop, but the gesture did not violate any identified law. The officer indeed has not argued to the contrary, and good for him because he has no leg to stand on there. Nor does her gesture on its own create probable cause or reasonable suspicion that she violated any law. And I wish more police knew this. Just because you're mean or rude or even want to curse the police does not give them grounds to give a seizure of you or to search your property. So this really holds for that proposition, and this is a good day for that. The court continues. Minard adds that no case puts him on notice about this fact pattern, that the second stop after the first stop supported by probable cause violates Cruz Gullis's Fourth Amendment rights. Defined at that specific level of generality, he says the case law did not clearly prohibit the stop. But Minard misses the point. In making his argument, he fails to acknowledge the second stop was distinct from the first stop, not a continuation of it. So when it talks about the level of granularity, this is an important aspect in qualified immunity doctrine and an issue that comes up quite a bit in these kind of controversies. When you talk about a clearly established right, how specific do you have to be? How clear does that have to be? Because you can always argue that any case resolved at a low enough level is a unique case. There's no two cases that are going to be precisely the same. You find something. So it can't be true that that at that level of generality you have to have notice because you never would. At the same token, it can't be just a very generalized thing. It has to be relatively well tailored to the fact pattern, and the court says it is here, and I agree. The court continues. No matter how he slices it, Cruz Gullis's crude gesture could not provide the new justification. While these cases are not factually identical, because again, that would be hard, they establish clear, specific principles that answer the questions this case asks. At this stage, Cruz Gullis's allegations survive motion for judgment on the pleadings based on qualified immunity. So again, just to be clear here, the trial has not continued. This was a civil trial, and this was a preliminary motion to dismiss, basically. And the trial court refused to grant that motion for a dismissal, and that's what's being fought over here. So it hasn't been found that this is factually true, and that's really important. When the appeal court is making a decision, they look to make the decision in the light most favorable to the other side. So the fact that the officer is bringing this case here, they're going to assume all the facts are to the contrary, because if he wins, if all the facts are to the contrary, then there's no need for a trial, right? If all the facts go the other way and he still wins, then he wins as a matter of law. But here, when they do that, when they say, okay, we're going to assume, we're not finding, but we're going to assume that all the facts are in favor of the person who was stopped, when we make that assumption, the officer loses. Now, that doesn't mean that that's true. They still have to go back to the trial stage, and there still would be testimony, and a jury or a judge is going to still have to make the decision as to whether or not this fact pattern, as is repeated here, is what actually happened. There has not been a finding from a trial court that this is factually true. This is just being assumed for the sake of argument, and it still has to be established at trial. So that is really important to keep in mind as we're reading this. The court continues. In his reply brief, Minard analogizes his case to a prosecutor who might reasonably think that he could take a plea deal off the table if a defendant behaved offensively, or a judge who might reasonably think he could increase a defendant's sentence if the defendant raised his middle finger at her right after he read his sentence from the bench. Judges, it is true, have a wide latitude to consider expressive conduct during sentencing, citing a prior case. But we need not wade through these complicated questions now because the facts differ materially. As alleged, the first stop had ended a constitutionally significant event before the officer initiated the second unjustified stop. The Supreme Court has said any justification for the first stop ceases when the stop ends. And so also there's a substantive due process claim here, but the district court offered no independent analysis. Minard offered no analysis, and so the court says, well, no one below came up with anything. We don't really need to decide this question because we already decided it on the First Amendment issue. So, we don't care. Maybe there was a violation of substantive due process. Maybe there wasn't, but it doesn't matter because the person gets to proceed under this theory. So we don't really care about this other theory. And actually, this happens quite a lot in court cases where if you come up with multiple reasons for the court to agree with you, they'll usually just pick one and say you win under that and not decide the other 18 that you brought up. It's an issue of judicial efficiency and also an issue with judicial restraint. So, my friends, that's the case of Cruz-Goles versus Minard. It's a follow-on to a very, very famous case in First Amendment law, 1971, Cohen versus California, which held that it's completely legal for a person to wear a jacket in a court hall that says, "Fuck the draft." And now, 2019, we say it's completely legal for you to tell a police officer, "Fuck the police," whether that's via words or via gesture. Again, I wouldn't necessarily recommend it for many pragmatic reasons. It's perfectly legal, but it may not be advisable. But, if you happen to be in this situation and you do so after the ticket is completely done, this is important. It has to be over. If you do it after it's completely done, they pull you over again, you too can recover. So assuming the facts turn out to be as Cruz-Goles alleges them, because that hasn't been determined, then she's going to be able to recover, and she's going to be able to recover from Minard personally. Yeah, pretty interesting times, my friends, indeed. So yes, the middle finger is still legal. But I'm not going to curse you, my friends. I hope you're well until later. Cheers and goodbye.